Good evening, ladies and gentlemen, and welcome to this evening's seminar. The purpose of meeting here tonight is to inform you of recent developments in employment law in the UK. I know we have in the audience this evening some employers from large corporations and some from more modestly sized businesses. We also have a few employees of the same, some trade union representatives, and also a few legal professionals specialising in this area of law. I hope that you'll all find tonight very useful. I'd like to open our discussion this evening with a controversial matter, that of the cost of bringing a claim before an employment tribunal. As you all know, it's no longer free for an employee to start proceedings against his or her employer. As from July 2013, any employee who wished to file a claim with a tribunal was required to pay a fee. Hitherto, of course, there was no charge. The amount an employee now needs to pay depends entirely upon the nature of the claim. In case you're not aware, for fairly straightforward matters such as unlawful deduction from wages, holiday pay disputes or redundancy payment claims, the cost of issuing a claim is £160 and the hearing fee is £230. For more complex claims, for example, claims for discrimination, equal pay or unfair dismissal, the issue fee is £250 and the hearing fee is £950. This obviously pushes the cost of bringing an employer to a tribunal to over £1,000. The government states that the aim of the fee is to ensure that people using employment tribunals contribute to the cost of running the system, rather than the full cost being met by the taxpayer. It also states that it wishes to encourage people to look for alternatives, such as conciliation, before issuing a claim. In addition, many employers in this room may argue that the introduction of fees was needed to reduce the number of vexatious claims issued against them. Prior to 2013, employers had very little to lose from making a claim, whereas employers, by contrast, typically incurred legal fees in defending themselves. Unsuccessful tribunal claimants are generally not required to pay a defendant's legal costs, meaning that employers were left out of pocket whatever the outcome and would often offer to settle a claim, notwithstanding the fact that the employee may actually have had insufficient grounds for bringing the claim. However, conversely, there are many people in the room who'll argue that the introduction of such fees has had a significant adverse impact on access to justice, and that the fees are often disproportionate to the amounts claimed. They also argue that the system for waiving or reducing the fee for those with limited savings and low income is too strict and too complex. A report by Britain's trade union central body, the Trades Union Congress, better known as the TUC, states that the fees are a huge victory for bad employers. The TUC has also made clear that women and low-paid workers have been the worst affected by the new charges. Reports have shown that since the implementation of the fees, the number of claims brought to employment tribunals has reduced on average by about 70%. But now it seems that these fees may become a thing of the past. I'd like to highlight to you the fact that a case was heard in the Supreme Court in March 2017 brought by the trade union Unison against the Lord Chancellor and current Justice Secretary Liz Truss. Unison is arguing that the fees are preventing many mistreated workers, particularly those on low incomes, from obtaining justice, and that they are therefore discriminatory. Unison has previously been unsuccessful in both the High Court and Court of Appeal, but was granted permission for its case to be heard by the Supreme Court. Obviously, the judgment in this case will have significant consequences for everyone. If the fees are abolished, there'll no doubt be a sharp rise in employees pursuing litigation against their employers. I would therefore advise everyone here to ensure that you are aware of the impact of this case. Even if Unison is unsuccessful, the Justice Minister, Sir Oliver Heald QC, in response to a government review in January this year, has recommended fees be abolished for the lowest paid. There is no doubt, therefore, that the eligibility criteria for those who may not need to pay the fee will change, and therefore it's extremely important that you are aware and up to date.